Good morning, I'm Alexander Nissen and thank you for being part of Keating Chambers' live webinar programme. Many of you will know that for the last few years we have presented a Keating Chambers Silks Roadshow, which tours a number of cities with high quality talks. For obvious reasons, we've parked up our tour bus for the moment, and for the first time we're doing the Silks Roadshow in a live webinar format. This is the first of two. Today's session will be followed by further speakers on the 16th of July, so do please join us for that. As we're not in a conference hall, I don't have to tell you that if the buzzer sounds, it is not a fire test. Instead, I have to tell you that if the buzzer sounds, it's my Ocado delivery man. I'd like to introduce you to today's speakers, Simon Hargreaves QC and Sean Wilken QC. Over the next 20 minutes, Simon is going to cover contribution proceedings under the Contribution Act, and Sean will then follow for 20 minutes on COVID-19 and its impact on commercial and construction law, including questions of force majeure and construction claims. After that, all three of us will take part in a 15-minute Q&A. You can submit questions on both of the talks during the sessions by opening the QA box and typing and submitting your question on the right hand side of your screen. So do please type in some questions as they occur to you. So we turn to the Contribution Act. As someone whose client is about to be joined into contribution proceedings by Simon's clients, I've obviously got a very keen interest in hearing precisely what he has to say. I'll hand over to you, Simon.
Okay, thank you very much. Welcome to everybody and thank you for coming. My talk is about contribution proceedings. The slides that we have are for a much longer talk, which comprises questions of limitation and questions of what amounts to same damage under the Civil Liability Contribution Act. And the slides will be distributed afterwards, and you're welcome to look, as it were, at the longer talk. The slides are also accompanied by a document that looks like this, with A's, B's and C's and various arrows on it. That set of diagrams is intended more for the longer talk, but it's also quite useful to have it to hand in order to bear in mind the structure of contribution claims and how they work. So with that introduction, this morning I'm going to talk quickly about quirks of limitation arising in relation to the Civil Liability Contribution Act 1978. And in particular, the headline that I'm trying to communicate by this very brief talk is the possibility of resurrecting apparently hopelessly time-barred claims by using one of the quirks available under the Civil Liability Contribution Act, which involves principally settling proceedings up the line and then bringing proceedings in contribution. And it's possible, in the right circumstances, to resurrect apparently doomed and hopelessly time-barred claims by this means. So with that rather cryptic introduction, let me start running through the slides. There's the title of the Act. Here is section 1 of the Act. It's a notoriously dense Act, very complex, and often has to be unravelled like the layers of an onion. But there is a fairly innocuous beginning. Subject to the following provisions of this section, any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage. And that's the classic ABC triangle, where you have, if you look at the diagrams at page 1, or I can hold them up like this, you have B is liable to A in respect of damage, C is liable to A in respect of damage, and therefore the question is, can B make a contribution claim against C? Here is a broken down version of section 1.1, and I've put in red numbers what one might describe as the danger areas, the areas that need more thought when one is examining this, as I say, extremely dense act. Moving on, I've broken down the principal elements of a claim in contribution. And if one imagines A at the top of the triangle and B and C at the bottom left and bottom right respectively, those are the three propositions which I've outlined. B must be liable to A, C must be liable to A, both in respect of damage, and the damage must be the same damage in each case. So then let's start looking at the limitation puzzles. What if by the time the contribution claim is brought by B against C, the notional claim by A against C, because remember that C must also be liable to A, would be time barred? So that's the question. So what that means is we're focusing on this, the red element of a contribution claim. So the question is, can C say, well, hang on a minute, if A brought its claim against me now, then that claim would be time barred. And so I, C, am not liable to A, and therefore for that reason B cannot bring a claim for contribution against me. And that's a perfectly logical question. This question can arise, for example, when A has brought proceedings against B close to the expiry of the limitation period for A's claim against B, and hasn't brought proceedings against C at all. It may be that A's claim against C is already time barred, or it may be that A takes the view that his claim against C is no good, or he may think that B is good for all the money. So there's lots of reasons why it might happen. However, B takes a different view and he wants to bring contribution claim proceedings against C. So can C say, no, A's claim would be time barred, so you can't bring a contribution claim against me? Well, the answer is no, he can't say that. This is provided for in the Act at subsection 1.3. And one can read the section, a person shall be liable to make contribution, notwithstanding that he ceased to be liable, ... unless he ceased to be liable by virtue of the expiry of a period of limitation or prescription, which extinguished the right on which the claim against him in respect of the damage was based. And of course, those of us who still remember what we learned at law school will remember that the Limitation Act 1980 bars only the remedy and not the right. So even where A has not sued C because A's claim against C was time barred, then provided he can still sue B, B then can bring contribution claims against C despite the fact of that time bar. That is the effect of the Act. Now let's get on to the much more interesting aspect of that, because that's a well-known situation. How else might C defend the contribution proceedings? Can he look at this limb, the one in red? Can he say, well, B is not liable to A? In other words, the very person that's bringing the contribution claim against C, that is B, is C allowed to say, well, hang on a minute, you, B, are not liable to A because A's claim against you is time barred? That's a complicated question, and that's really the substance of this talk. So what we have to do is we have to start with subsections 1, well, we have to look at subsections 1, 2 and 1, 4 of the Act. Let's start with subsection 1, 2. This says that a person shall be entitled to recover contribution. So remember, that's B. He shall be entitled to recover contribution by virtue of subsection 1 above, notwithstanding that he has ceased to be liable in respect to the damage in question since the time when the damage occurred, provided that he was so liable immediately before he made, or was ordered, or agreed to make the payment in respect to which the contribution is sought. So in other words, that section is saying that B can recover contribution despite having ceased to be liable, provided he was liable immediately before any of 3 scenarios. That is, immediately before he made the payment, immediately before he was ordered to make the payment, e.g. by a court, or immediately before he agreed, e.g. by a settlement agreement, to make the payment. Those are the 3 scenarios. Now I've highlighted 2 of them in red. The one that's not in red is more straightforward, because quite often that will arise in circumstances where A and B are already in the proceedings, and so the question of limitation is going to be determined in those proceedings, but it doesn't have to be. But much more interesting are the two in red, namely immediately before he made the payment and immediately before he agreed to make the payment. And so in those senses, it doesn't matter if before those scenarios he was not time barred. But we need to look at the first and third scenarios in more detail, and we need to look at subsection 1.4 in order to do that. And this is where it gets really interesting. And what this says is, a person who has made or agreed to make any payment in bona fide settlement or compromise of any claim, ... should be entitled to recover contribution in accordance with this section. And listen to this, without regard to whether or not he himself is or ever was liable in respect of the damage, provided, however, that he would have been liable, assuming that the factual basis of the claim against him could be established. So this is not a situation where B has been ordered to make the payment by the court, and this may well be a situation, and indeed is likely to be a situation, where A is not now involved in the proceedings because B has made or agreed to make a payment in settlement of A's claim. So the question that arises, well, in what's the extent of what C can do by way of defending that claim? And in particular, is C allowed to say, well, wait a minute, that claim that you settled would have been time barred. It would have been time barred, and I can defend your contribution claim by saying so. Is that allowed? That's the question. Well, here's the answer. The case is called Nissen versus IMI, and I'm going to have to run through the facts a little bit, just looking at the time. The facts were that several companies were operating a copper fittings cartel. When the commission produced its report, Travis Perkins, who you don't see in the title, but the claims were settled with them, but it was they originated the claims. They sued two members of the cartel for breach of statutory duty. One was IMI, who you see in the title. IMI defended the claim brought by Travis Perkins by pleading limitation. And on the face of it, it was years ago. The claim was obviously time barred. But Travis Perkins responded by pleading deliberate concealment. They couldn't have found out until the commission reported. Meanwhile, IMI brought contribution proceedings against Delta. Delta pleaded in relation to those contribution proceedings that yes, indeed, Travis Perkins' claim against IMI was time barred, and therefore there could be no liability, and therefore there could be no contribution. And not only that, but Delta refuted the deliberate concealment defence by raising positive averments as to how Travis Perkins could have known about the cartel much earlier. So what then happened was this, sorry, I'm trying to look at my notes. IMI settled Travis Perkins' claim. IMI cleared the decks of other Part 20 claims and proceeded against Delta alone. Delta said, you can't claim contribution against me because you were never liable to TP because the claim was time barred. The deliberate concealment allegation would have failed and IMI's limitation defence would have succeeded. So that was Delta's case. IMI said, oh no, you can't argue that. The effect of section 1.4 is that you're not entitled to look into the question of limitation. I just need to show a bare case that my claim, if the facts were established, would have succeeded. Well, that went to court and then on to the Court of Appeal. So let's look at the section again before I tell you how it unfolded and then try and look at how it might be useful for other matters. I've marked two sections 1 and 2. If the Act stopped after the underlined bit introduced by the red number 1, in other words, if it said shall be entitled to recover contribution without regard to whether or not he himself is or ever was liable in respect of the damage, full stop, then that would be clear. It would be that IMI could recover contribution from Delta because those clear words say it doesn't matter whether you were or you weren't liable. If you did a bona fide settlement or compromise, then that's the end of it. But it doesn't say that. It goes on to say that 2, provided, however, that he would have been liable, assuming that the factual basis of the claim against him could be established. And of course, what that That was the focus of the court's attention. What does that mean? What does the proviso at number 2 mean? Now, I'm not going to be able to go into the complexities of the first instance decision, but that was based on a host of authorities that preceded the case, and there was lots of wrestling to try and, but the law had essentially taken a wrong steer. But the Court of Appeal put matters right, and it was Sir Colin Rymer in the Court of Appeal, and he went through the Contribution Act in some detail, providing a great deal of clarification. And a good overview and explanation of the Act is found at paragraphs 48 to 53 of his judgment. Now, in short, IMI said that all the proviso was concerned with was Travis Perkins's case against IMI. It was not concerned with IMI's defences. And they said, well, this construction is appropriate because otherwise there would be a trial within a trial of the original claim, now settled, within the contribution proceedings. Delta said that earlier cases, including one called Hashim, had determined that although the assumption in the proviso only went to the factual basis for the substantive claim, nevertheless, the proviso extended to collateral defences, so that if there was a collateral defence such as limitation, that could be looked into. The conclusion on the point, which has troubled practitioners for a great many years, was made very clear by Sir Colin Rymer. Here's the relevant passage. That construction, that's to say Delta's, it doesn't permit. It's provided expressly there has been no inquiry whether D1 was or was not actually liable, and the proviso cannot therefore fairly be qualified as implyingly qualifying that prohibition, so as to let in an inquiry directed at showing that D1 was not actually liable. Such an interpretation is repugnant to the express intention of the primary provision. And he was good enough to put it this way about the judge in Hashim, Justice Chadwick. I may say so, I consider that Mr. Justice Chadwick focused too closely on the trees in the proviso without also standing back and noting the nature of the wood in which they'd been planted, and then switching metaphors. He said that the result was that he wrongly allowed the tail of section 1.4 to wag the dog. So where does that leave us then? Well, the limit of the inquiry permitted by the proviso in section 1.4 is therefore that he has to show that he would have been liable to the claimant with whom he's now settled, assuming that the factual basis of the claim against him could be established. In my judgment, all that D1 needs to show is that such factual basis would have disclosed a reasonable cause of action against D1, such as to make him liable in law to C in respect of the damage. If he can do that, he will be entitled to succeed against D2. In other words, the contribution claim will succeed. And then he goes on to say, but this says nothing about quantum. The upshot was that Delta wasn't able to raise a defence to the contribution claim by saying, hang on, the claim made against you, in respect of which you're now claiming from me contribution, was time barred and you were never liable. Now, of course, had there been no settlement and had Travis Perkins continued against IMI in the action and IMI against Delta and so on, then Delta would have been able to rely on a defence along the lines that IMI was not liable to TP because the TP claim against IMI was time barred. So I've summarised this on this slide. If B settles A's claim against it, C cannot argue in contribution proceedings that A's claim against B was time barred, so that C is not liable in contribution. If A's claim against B proceeds, and assuming C is in those proceedings, C can argue that A's claim against B was time barred, so that it is not liable in contribution. So that's an unusual situation. It's worthy of comment, and it is a quirk of how the Contribution Act deals with limitation. So coming towards the end now, if B settles A's claim against it, that this is the sort of menu that one's looking at. The first proposition is what unfolded from Sir Colin Rymer's judgment. The second proposition is just picking up the fact that quantum, there are no assumptions made about quantum. But the third point, and this is really this is the limit of the fence surrounding the operation of section 1.4, if I go back to it, I'll show you in a minute, C can argue collusion, dishonesty or absence of bona fides in the compromise, but that's all. So just going back to look at the subsection there, this is me referring to the first couple of lines. A person who has made or agreed to make any payment in bona fide settlement or compromise of any claim made against him. And then all the consequences that I've unfolded follow. You know, in other words, not being able to plead limitation of the original claim, subject only to whether the settlement was effectively a bona fide settlement. Now, in this case, the question arose, this is Abbey National, well, is as it were, creating a settlement situation so that you can then take advantage of that limitation quirk under the Civil Liability Contribution Act? Is that legitimate in itself? Is that bona fide? To which the answer was, well, or appeared to be, well, yes. And I've set out on this slide one of the challenges brought. One of the challenges, so basically a bank sued a surveyor and a solicitor in relation to a loan and an overvalue and all the rest of it. So one of the challenges raised by the surveyor was that the settlement agreement was not bona fide because the pursuit by Abbey National of the claim enabled Abbey National to circumvent the limitation defence which the surveyor would otherwise have had. In other words, the bank settled with the solicitor, and then the solicitor then sued in contribution the valuer. The bank would have been time barred against the valuer and against the solicitor. And so that's not entirely accurate. But anyway, this here now is the summary of what the judge had to say. I do not see how the achievement of a means to avoid a limitation difficulty can be regarded as not in good faith. If such means is available, then there is no reason why advantage should not be taken of that availability. So this is a great deal of food for thought. If one imagines a situation where owners of a block which has unsafe cladding, for just to choose a current example, are pursuing the developer for remedial works, but the owner's claims against the developer are time barred. But even so, for good reasons that one can understand, the developer nonetheless considers that he ought to replace the cladding, then perhaps this gives a possible route of recovery by the developer. He settles with the owners on terms that money is transferred and repair works are carried out by some means or another, and we'll have to think about that, and then brings contribution proceedings against the contractor. So on this scenario, despite the fact that the owner's claims against the developer would be time barred, and despite the fact that the owner's claims, if any, against the contractor would also be time barred, and remember there would have to be liability together to A, but the Defective Premises Act, for example, could give you that route, then there is a possible route via section 1.4 of the Act, whereby the developer who settles with the owners can still bring contribution proceedings against the contractor. And that is the gist of this talk. That is the food for thought that I offer you to go away and digest. Now that brings an end to my talk. There are many more slides. Please look at them at your leisure. But I only have a short time on this, and so I'm going to close there with that food for thought, and thank you very much for listening.
Thank you, Simon. Very helpful. I'm now delighted to welcome Sean Wilken QC to his first Keating Chambers Silks Roadshow. Sean's going to talk to us about the legal implications of COVID-19, both statutory and contractual, with focus, of course, on the impact on construction works on site. This is obviously a fast-moving topic, and some certainty, therefore, and clarity from Sean would be welcome, and let us hope you catch something useful from it. Don't forget, please, to post some questions as they occur to you by opening the Q&A box and typing and submitting your questions on the right-hand side of your screen. Right, I'll hand over to you, Sean.
Good morning. Thank you very much, everyone, for attending. I'm also going to be talking about a very complicated and Byzantine set of government legislation and regulations and guidance, which is the current response to SARS-CoV-2, as it's known. The first slide appropriately is called confusion. We have daily changes of policy. We have more than weekly changes in guidance. Every Sunday afternoon, one can have the joys of COVID spotting as you wait for the new amendments and new regulations. We now have severely different approaches in England, Scotland, Northern Ireland and Wales. We have different entities issuing different guidance, and now we have a thing called the Joint Biosecurity Unit or Centre, which, try as I might, I still can't find any basis in law or fact for. A word about timing. As this has progressed legally, we have seen that the position alters, as I've said, weekly or daily. Therefore, you have to look at the position. If you are looking at claims, you have to look at the position as it was then. This is made more difficult as the websites have now been altered with retrospective effect. In other words, if I try and click on a link that showed me the guidance in March, I actually get the guidance as at the 14th of June. So you have to start using tools like Wayback Machines to find out what was said when. And here we come to perhaps what I will be talking about quite a bit today, which is the COVID critical path. We are used to critical paths in construction. We all know how they work. In COVID, you have to generate your own critical path. You have to look at what was happening in the legislation and then check it against what was happening on site. So we start on the 10th of February. We have SI 129. SI 129 is a traditional, in inverted commas, public health measure. It allows people who are infected to be basically placed in hospital. And no one has suggested, as far as I'm aware, that SI 129 caused any problems. You then have the lockdown on the 23rd of March, but the legislation for that doesn't start until the 25th of March, when you have the Coronavirus Act, you have SI 350, which has now been multiply amended, which is the relevant statutory instrument. Then, apologies for the date, this is actually a month out of the way, you have, this should be April, 2nd of April 20, SOP 2 from the Construction Leadership Council is introduced, but it's withdrawn 2 hours later. You then have a further statement of operating practice on the 14th of April. The next big development is the 10th of May. Here you have the Prime Minister's speech, namely that we are entering a new phase, we are loosening lockdown, but none of Scotland, Wales or Northern Ireland go for this. The speech, however, does trigger, between the 11th and the 13th, multiple sets of differing guidance. But that doesn't actually make its way onto the statute books or the statutory instrument books until the end of May. The statutory instrument is then amended again, and then we have the regulations in relation to public transport and masking, and then 2 days ago we had the announcement of basically the end of social distancing. What does all this mean? In relation to England, we have 3 statutes, 6 sets of regulations. By the way, I count at least 22 across the whole of the UK, and I'm not talking about schools, because once you get into schools, it's changing day by day. The statutes. One would expect the Civil Contingencies Act to be used, it wasn't. And one would expect the Coronavirus Act to be used, it wasn't. Instead, they used the Public Health Control of Disease Act in 1984, which has attracted some academic criticism. That has created the regulations, SI 350, which has been amended 4 times. It actually needs amending again, because as it currently stands, it doesn't reflect government policy. It's probably unlawful in 2 ways. One, the Public Health Control of Disease Act actually doesn't give the government power to do what it's done. And 2, whilst one can see the first set of regulations back in March being a permissible exercise of emergency powers, it's very difficult to see now why we're seeing this repeated use of emergency powers. It just doesn't work. They're also unclear. This means, in essence, there is a strong probability that the regime is unlawful. which means if you are responding or making a claim, there is a probability that the cause that you're relying on, namely the regulations, is unlawful, which is a new and untested position. I was attending a lecture with Ewan McKendrick, and he was asked what happens if you have force majeure where the whole regime is ultra vires, and he went, ow, that's a difficult point. Anyway, relevant regulations, and you will see here that I am time slicing. So this is 25th of March to the 1st of June. You could leave home to work as that was a reasonable excuse, but, and this is important for sites, Regulation 7B, no gatherings of more than 2 people unless the gathering is essential for work purposes, and that is backed by criminal sanction. From the 1st of June, you have a very different regime, namely you have overnight curfew, and gathering which is reasonably necessary for work is permissible. So I say that after the 1st of June, the regulations are exceptionally weak. A, what is the concept of reasonably necessary? It seems to me that that is close to being an oxymoron. B, it is difficult to say that you're bringing people to site is not reasonably necessary. So the 1st of June, if you are looking at responding or making claims, is going to be an important date. Brackets until we enter phase 2 or wave 2 or whatever comes next. Well, moves from the regulations to the guidance. You have at least 13 sets of it. If it's issued by Public Health England, that's under statutory power, see section 2A of the National Health Act. Public Health England, however, has now been sidelined. It's now all in the Cabinet Office under prerogative, or by the Joint Biosecurity Unit or Centre, in which case we simply do not know what powers it's exercising, if it even exists, because Matt Hancock has said on one day it does exist, on the next day he said it didn't. The wording, increasingly vague over time, it's inconsistent. So at the relevant time, say from about May to the end of June, Public Health England said you had to have 2 meters, Cabinet Office did not. Current position as per guidance still remains work if unavailable to work elsewhere, socially distance if practical, focuses all on the employer's assessment. We now have 2 days ago the assertion of a 1 meter change, but we don't know how that will be implemented. We also have further guidance, guidance on responsible contractual behaviour in the performance and enforcement of contracts impacted by the COVID-19 emergency. It does contain provisions relating to force majeure, delay, extension of time, compensation, but explicitly said not to have the force of law. Public-private law, and you can tell I'm racing here because I'm collapsing what is a 45-minute talk into 20 minutes. The distinction between hard and soft law. Soft law is usually what guidance is. So what does this all mean in terms of contracts? We have the JCT change in law statutory requirements wording, which we'll all be familiar with. We have change in law, which is common in PFI, and you have force majeure wording, where you have various specific phrases which may or may not help. This is covered in a previous Keating Chambers webinar, which is on the Chambers website. You can see it there, the papers are there. I invite you to look at them. So force majeure up to 1st of June. 2 critical points. Showing causation, namely that the regulation or the guidance made performance impossible, is going to be very difficult. But it all turns on the wording of the clause. So you have to look at, for example, if there is sole cause versus impacted by, or prevent versus hinder. So prevent is in some FIDIC wordings, hinder is elsewhere. Prevent performance is going to be very difficult for anyone trying to establish force majeure. Impact, regulations up to 1st of June. Headline points, if lawful, NB, they are probably caught by the JCT wording, and probably you can make an argument on regulation 7. So I think that may be a change in law, but once you move away from the regulations, one gets into the guidance. Now, the orthodox view, which is the one that all employers will be signing up to, is that guidance is soft law, therefore it's not binding, therefore it cannot be a change in law. But NB, if there is a public body in the chain somewhere, that will be different, because public bodies have to take account of guidance. They then have to exercise their decision-making power, which may attract a good faith obligation or a not capriciously exercised obligation, to differentiate themselves from the guidance. Similarly, if you're relying on the PHE guidance, it's under statutory duty, therefore under the JCT wording, that's a rule made under statute, and the other guidance is directive. So that element of the JCT wording is met, but does it have force of law? Here is where the argument gets interesting. Under the Health and Safety at Work Act, sections 2.1 and 3.1, there is a duty for employers and non-employees to have a safe place of work. The argument is that the guidance dictates what amounts to a safe place of work, as it says so. So it would be treated as setting a standard. Now, at one stage, this argument had some legs because the HSE said it would prosecute and enforce. But then the HSE turned around and said, actually, we won't. Similarly, the government said it would enforce and then said it wouldn't. And then yesterday it said, oh, well, we might do. So this argument will come in and out of focus depending on what the HSE and the government say they will do. This is why what they say they will do is important. To attract a criminal penalty, a provision must be sufficiently certain to have force of law, otherwise it'd be arbitrary punishment. So this guidance, if it is enforced, is guidance as we used to know it, but to quote Star Trek, but not as we know it. But also note the timeline and the changing position over time. Force of law. I come back to the fact there are 2 judicial review challenges on foot. If they are successful, and the ultra vires challenge succeeds, the regulations were void and never had effect. Now, I think, and I'm not alone on this, so Lord Anderson of Ipswich and various people, various silks of Blackstone Chambers who are running the challenges, think that this argument has a reasonable prospect of success. So very difficult question of the relationship of a result in that judicial review with contract law. And after the 1st of June, I think it's very difficult because the regulations are so nebulous that they have effective force of law or relevant force of law. And if that's right, the guidance doesn't have force of law either. We now have a thunderstorm up here, hence the dog barking. The joys of COVID isolation. Devolved administrations, I cover these off relatively briefly because I know many clients have projects in Scotland and elsewhere. Luckily, I've never been asked the question, and I really hope I won't be asked the question, about what happens with a cross-border dispute, because the position in Scotland is different. So Scotland did use the same act, so the same questions about vires apply. The guidance suggests that all non-essential construction sites should close, and there was a very strong rhetoric from government that sites must close. But when you go to the Scottish regulations, construction sites do not appear in the must close, and they haven't used their Coronavirus Act powers or discretion. So the position in Scotland seems to be parallel to a case called INEOS. INEOS concerned a fracking ban. So the SNP and the First Minister had said they banned fracking in Scotland. But when you looked at the actual instruments, there was no mention of a ban. This was taken to the Court of Session, and it was held that despite the assertions that there was a ban, there wasn't a ban at all. And so I think the closure of construction sites in Scotland will have similar issues in that if it were to be challenged, it would be found that the policy was not a policy and was not a ban. But differences as well. Social distancing in Scotland is still the law. In other words, they've translated social distancing of 2 meters from guidance into the regulations. There was no loosening at the end of May, and we are still in lockdown up here. Wales, they have the same regulations, but like Scotland, they have guidance has force of law. So what they have done is said all guidance that we issue is legally binding on private parties. And social distancing has force of law as well because it's in the regulations, and no dilution in May. Northern Ireland is the same, but no dilution in May. So the wrap up. The headline points. There has been, in my view, a massive risk transfer from government to the private sector. This is because what government has done by this melange of regulation, guidance, statements, etc., is just say to the private sector, you sort it out. What we are seeing is that current contractual risk allocation mechanisms are probably inadequate. And similarly, what is going to be difficult is to see how you can make provision. If I was signing a contract today, what terms would I need to put in to cover this? We have in force majeure clauses the idea of restraint of princes. Can one have a clause that simply says, well, if government does something random in relation to COVID, or all COVID risks are hived off, can we have clauses like that? As I've indicated, cross-border issues are completely unsettled. And are we ending up with private sector bodies having to think about judicial review as a risk control mechanism? If you are talking about claims, the key issues, causation. Did the guidance for force majeure render performance impossible? That is going to be difficult, I think, to establish. It's going to be more expensive, yes, but impossible is going to be a stretch. Was the guidance likely to be one of numerous factors affecting performance? Undoubtedly, yes. So you have to look at the clause to see whether you've got a sole cause mechanism. Did it impact on the works as per the JCT wording? There are some ways of getting impact on the works in. Look at the prelims, see whether or not there are questions about site access, health and safety, and compliance with regulations, particularly CDM. I've got at least 2 cases on the go where CDM is in play as a means of incorporating the guidance. Rapid issues 3, what of the contractual guidance? So you have this guidance from government that everyone should be nice to each other. What does it mean? As a black letter lawyer, it has no effect whatsoever. If you're being more purposive, Ewan McKendrick was interesting on this point, because he said, well, yes, it has no effect, but it should, and it might do. So that led me to thinking, well, how could you give it effect? Would there be an implied term? Would there be purposive construction? The difficulty with that, of course, is if we're applying contractual orthodoxy, neither of those work because you have to have the intention of the parties at the date of the contract. And axiomatically, we didn't think about COVID at the date of the contract because that's why we have force majeure arguments. And if it were imposed by government, it would be unparalleled and there would be Article 1 First Protocol ECHR issues. Thank you very much. I'm coming to the end of my 20 minutes and I believe that is now time for Q&A.
Yes, thank you very much, Sean. That was very interesting and topical. We are indeed now going to move to the Q&A part of the session. So we've got a couple of questions at least for Simon, if he's able to answer those on the Contribution Act. The first is this: if there is a contractual limitation clause in the parties' agreement, which is wide enough to cover claims arising out of or in connection with the agreement, e.g. contracts and tort claims, do you think that such a clause could also prevent contribution proceedings?
Yes, that's a very good question. One has to remember that claiming contribution is a claim arising from a statute. My immediate reaction to this question is to say, as always, one would have to have a very close look at the words used in the limitation clause. But I would not expect such a limitation clause to be successful unless it mentioned either directly or by using words like contribution or related claims or what have you. I would not expect it to be able to rule out a claiming contribution unless it made some attempt to grapple with that concept with express words. So there may be a case that I may be wrong, but that's how I would answer that question without reference to my books.
All right. Thank you very much. Another question which had occurred to me certainly was your reference in the statute section, I think it was 1.3, to ordered by the court. And the question really is this: what happens if somebody gets an adjudicator's decision which is then summarily enforced? Would that fall within the wording of ordered by the court?
Well, we had a pact before this talk that we wouldn't bowl any fast Yorkers at each other. So thanks very much for that. That's again a difficult question. I imagine that because, of course, if one was to bring a claiming contribution based on an adjudicator's decision that had been enforced, and yet proceedings remained live by the party who was, as it were, the victim of the adjudicator's decision, and who was bringing those contribution proceedings, C, who is in receipt of the contribution proceedings, would say, well, hang on a minute, you can't enforce a contribution against me in relation to a temporarily binding enforcement of the decision. You can only have, because in the end you'd be looking for a judgment in your contribution proceedings, you can only have that in the main proceedings, if any. Now, of course, a difficult question would arise if no proceedings were brought by the victim of the adjudication to undo the adjudication and say, well, the correct answer should be this. So I think the answer is that there probably would be some procedural way of working one's way through all that, and somebody may have to be put to their election in relation to court proceedings or arbitration proceedings if that was the, and of course if it was arbitration proceedings you couldn't bring a contribution claim. At least not within the arbitration. So yes, a very fast ball, a big mess, and I'm not entirely sure what the answer is.
Very good, thank you very much. Sean, a couple of questions for you. Firstly, I suppose that in a bullet point, is COVID-19 a force majeure event?
This raises the question of what do you mean by COVID-19? Do you mean the pandemic, or do you mean the government's response to it? If you mean the pandemic, then you're actually looking at, in essence, supply chain questions. So you're looking at, do I have a supplier in China or in Wuhan who has been locked down, and therefore I could not get my kit at that point? That is possible of being a force majeure argument, not least because a lockdown would count as restraint of princes under a lot of clauses. If you're looking about the government's response in England, I think that's a much more difficult argument. I think it is rather difficult to say that it is in and of itself force majeure, not least because, of course, you can still perform the contract. It's just more difficult, more complicated and more lengthy.
Another one which has been raised is this: should the judicial review challenges be successful and the regulations treated as void, as you suggested, you mentioned that raises some difficult issues for from a contractual law perspective. I wonder if you could just expand on that a little.
Yes, this is kind of a BCL exam question type. So if the judicial review succeeds on the basis that the regulations were ultra vires, So there was no power to make them. Not only are they unlawful, but they never existed. And if they don't exist, all the guidance falls over as well. So it's a classic domino. If that happens and you are claiming, then what you have is in fact something that caused you force majeure or delay or loss and expense or a change in law, which not only does not now exist, but never existed. The only parallel I can think of in that is the swaps litigation in the 90s. So for those who are legal historians, there were a series of transactions entered into by local authorities to get money. They did that by way of interest rate swaps. Those were held to be ultra vires, and then that spun off a mass of claims in restitution because all the contracts fell over. So what we will have if that happens, I think, in the claims situation, is a similar search for a contractual remedy in relation to this now non-existent event. And I think that will be very interesting. I'm afraid I can't be much more helpful because I actually don't have a simple answer. There isn't one. We've never seen it before.
Well, thank you very much. Simon, a question about reform of the Civil Liability Contribution Act. Is there any aspect of it that could be reformed? I mean, it's a very, as you said, it's a very short, tightly packed statute and doesn't often get looked at, but and a lot of unanswered questions. Is there any particular aspect you think could be reformed?
Well, I mean, I'm a big fan of the Act. I mean, where a piece of legislation that short makes my brain hurt every time I look at it, and where it appears to address itself to new situations by obscure sentences buried away within the depths of the onion, never ceases to amaze me. So it's a wonderful Act. It's beautifully drafted, but very hard to follow and apply sometimes, although eventually the light shines through the clouds and one gets there. There is one area though, because you'll all remember the case of Royal Brompton that as it were settled the debate about what amounts to same damage for the purposes of the Act. I think that my personal view is that was quite narrowly drawn actually, and there are a good many situations where you're not allowed to bring a claim in contribution, including the cases that were overruled by Royal Brompton. So, for example, a contractor may be liable for the situation giving rise to a flood. An insurance broker may be liable in not having provided for insurance cover in relation to a flood. Now, you may think that that's at the extreme end of something that should be same damage. It certainly isn't same damage for the purposes of the case law that we presently have. But you may think, well, why shouldn't the builder and or the broker be in a position to sue the other one? I mean, after all, at the end of the day, the premises are flooded, and one may say to oneself, well, you know, that's the damage. But instead, one ends up with all these metaphysical debates about what is same damage. And in fact, that is the second half of my talk. It's the longer part of the talk. Other situations include whether the miscertification of extensions of time and the facts of the delays themselves can be regarded as same damage, and that was what the issue was in Royal Brompton. Again, no. It seems to me that if anything could be reformed, it might be to make the Act, with all its qualities, more useful by broadening the definition of same damage. But really, at the end of the day, that's more of a quibble than that's personal preference, really, rather than a sort of deep legal thought. It's more a practical thought.
Thank you very much. We've had another question which I think follows on from the Court of Appeal case that you mentioned, but with the topical cladding theme to it. So A in your triangle is the freeholder of a building with defective cladding, B the original developer, and C the contractor. So A, the freeholder complains to the original developer about non-compliant cladding, but never particularises his legal claim, whether it's contract negligence or whatever, just does it in a letter of claim, could the developer still settle and seek a contribution from the contractor C because the factual basis of the claim has been established, even if the exact cause of action has not been nailed down because we hadn't reached pleadings and so forth?
Yes, well, that's an excellent question, and I'm pleased to see the uptake of the idea of getting around time bars. In a sense, this is untested, but in principle, a payment can be made in relation to a liability, and then the question of whether there was a liability is a question of mixed law and fact. That will then be examined by reference to the materials that are available, such as they are. And so, in a sense, one can improve the position by being careful with how you unfold the situation given your presumed involvement. And so, for example, one would say that before settling with any claimant in these circumstances, you would need to see exactly how they were putting their case, and at least need to know what the causes of action were, how they were formulated, and so on. But I don't think that one can be prescriptive. I don't think that there is there's a sort of gold standard that one would say was necessary, and anything short of it would not do. In the end, one will just have the facts that one has, and one will see whether they're sufficient to ground the claiming contribution. So that's not much of an answer, but it's intended to say that one has to proceed with care. One has to have a close look at the Court of Appeal in the IMI case, and one has to have a good look round to see if there are any other cases that examine this question.
Thanks very much, Simon. Sean, a question that's been raised. Do the Health and Safety at Work Act and the CDM regulations, which you mentioned, impose obligations on the employer, as defined under the building contract, to issue instructions for a change to change working practices, or should it be left to the contractor to deal with those changes on their own?
In the words of a politician, that's a very good question. I'm glad you asked it. I will now proceed not to answer it because it's actually very, very complicated. There is, in theory, yes, an obligation under the Health and Safety Act on the employer, but much will depend on the allocation of risk within the individual contract and how the CDM regs are dealt with. The reason why I'm hedging is actually this is a question I am looking at right now, and I haven't actually got to an answer. This brings me to another question which is asked, which is how do we think this will all play out? I think litigation is inevitable because so much risk has been transferred to the private sector and there's so much commercial uncertainty. And the contract terms as they exist weren't designed to deal with this. If and when litigation occurs, public policy will play a part, because what we're talking about, whom in the private sector ends up holding the commercial exposure for this? Where does the buck stop? And I think it'd be very interesting to see where the courts go on this. One can see claims which are carefully formulated having validity, but whether as a matter of public policy or, privately held views as to where COVID risk should lie, those claims do succeed will be interesting. As I say, we can all sit there with the regs, the guidance and the contract and via the timeline ascertain a claim. But one is always left with the problem that the guidance is guidance and not hard law. and that's always going to be a problem. And whether the courts translate what is soft law into hard law is always a policy question. So I'm sorry to sit on the fence to that degree, but I'm afraid we are where we are.
Yeah. I mean, certainly when we had all the problems that have arisen from Grenfell, everyone said, you know, this is all going to end up in the courts because there are lots of complicated issues arising, which indeed they do. But it's interesting that nothing in that arena has yet come forward. And in some cases, one thinks that these issues are actually too big and people are too frightened to test them in the courts for all their importance. And so they get resolved in some other way. I don't know what you think.
I agree where you have the situation like Grenfell, which is tragic, but is one building. Here, because we've got multiple actors across multiple sites, you've always got the issue that a small dispute which started in the county court then snowballs, goes up, goes up, goes up, goes up. And so one of those could be one that ends up in the Supreme Court, where the judges will have to decide it.
Yeah.
I agree the too big problem is there. I suspect sooner or later one will head to at least the Court of Appeal.
Well, thank you very much. That is all we have time for this morning. After this event, we're going to be resending out the handouts from Simon and from Sean, his PowerPoint slides and the article which he mentioned on COVID. The webinar recording of this event will, I understand, also be available. Can I remind you that the next Roadshow in this format will take place on the 16th of July. Will feature Sarah Hannaford QC, Simon Hughes QC and Adam Constable QC. Finally, can I thank the speakers this morning, Simon Hargreaves plus his phone, Sean Wilken plus his dog, and our excellent marketing team who have been pressing all the right buttons today. Thank you very much. Enjoy the sunshine. Have a good day. Bye for now.
Thank you.
Thank you.